Okay, ladies and gentlemen, let's get started. And welcome to those who are in the room, and welcome to those online, although I understand we've again got some IT issues which we'll sort out. This is the second of 3 lectures that we're doing on contract administration. Many of you will have been here 2 weeks ago for the first, and I did a longer introduction that night. Today, we've got to get through quite a lot. And so the only introduction I'm going to give to tonight is just to say the third one in the series is going to be in 2 weeks' time, when I'm going to be speaking on payments and pay less notices and certificates for payment under the contract administrator's responsibilities. And I'm just going to give you the heads up that in about a month's time, on Wednesday, the 30th of July, we will be at Maidenhead and we'll be giving a presentation. We have the chair of the JCT, and she is going to be talking to us about the changes under the JCT 24 set of contracts. So again, top speaker on a top topic. So this evening, we're now going to start, and we're going to be looking at extensions of time and delay aspects. And without further ado, I'm going to hand over to Seth, who is going to be your speaker for this evening.
Thank you. Thank you. Good. Okay. So topics for today is the JCT Minor Works 2016 and extensions of time. Why do we need mechanisms to extend time? What does this contractual mechanism allow? On what basis can time be extended by a contract administrator? Does the contractor have any contractual duty when applying for more time? In what manner should a request for more time be made? What must the contract administrator do with any request for more time? How should the contract administrator deal with 2 overlapping delays, often called concurrent delays? And should the contract administrator exercise candor considering applications? Does the contract administrator have a duty to act fairly? And if they do, to whom? What assistance does the case law provide? Okay, so let's move on to the JCT Minor Works 2016. This is the provision 2.8. It's a long paragraph, and as you probably know, it says, if it becomes apparent that the works will not be completed by the date for completion in the contract particulars or later fixed, the contractor shall thereupon notify the contract administrator. Where that delay occurs for reasons beyond the control of the contractor, including compliance with a contract administrator instruction, that are not occasioned by default of the contractor, the contract administrator shall give such extensions of time for completion as may be reasonable and notify the parties accordingly. Reasons within the control of the contractor include any default of the contractor, of the contractor's person, or any of their respective suppliers of goods or materials for the work. And that's exactly the same in the 2024 edition of the JCT Minor Works. So if we break that down, the contractor is to notify the administrator if it becomes apparent they are not going to finish within time. If the cause of the delay is not of the contractor's making, the administrator should extend time reasonably, but not if the delay is because of an instruction resulting from a default of the contractor or subcontractor. If the contract administrator gives a variation instruction, they should calculate additional time without waiting for the contractor's application. And if the contract administrator sees temperatures next week are 5 degrees or lower, they should give notice to stop the external brickwork and extend time a week. The contract administrator needs to ensure that at the end of every day, the contractor knows what the date is they have to finish by. And if they're going to stop the work because it's less than 5 degrees, they should maybe take a PDF print of the BBC weather forecast for that postcode and send it to the builder. And the contract administrator should send the contractor the calculations of how they get to the period of time they are extending work by. And of course, they must keep clear, concise records how each extension of time is calculated and whether they've accepted or rejected the contractor's applications.
Excuse me, I've got two queries. If I raise them now, or do you want to wait till the end?
If you wait till the end, yeah. Okay, so 2.8 is followed by 2.9, and 2.9 is to do with damages for non-completion. So as you know, if the works aren't completed by the date for completion, as extended, then the employer may require the contractor to pay or allow the employer liquidated damages at the rate stated in the contract particulars between the date for completion and the date of practical completion. So this really is the purpose of extending time. It's so that the contractor knows every day when they have to finish, and also if they're not finished, that the employer can deduct liquidated damages from any sum that is due. So with regards to notices, the contractor giving notice or the contract administrator giving notice, the JCT says that each notice, instruction, or other communication referring to the agreement shall be in writing, and unless otherwise stated, any notice or communication may be given to or served on the recipient by any effective means at the address specified in the agreement. So in dealing with important contractual notices and other communications, it's good to send PDFs, attach them to an email, and also maybe send a hard copy to the address in the contract. So this is an extension of time pro forma that JCT have produced. And we can see here that very important things are putting in exactly who is issued by, making sure it's the person in the contract, putting the employer and the address, the contractor and their address, the work situated at, and the contract date, just to make sure there's no confusion. And also to list, we can see the 23rd of November is the existing completion date, and then the new completion date, 14th of December. Now I've added in red what I think should be added, and that is how you get to the date. So in this particular case, which I've made up, there's an extra week because the builder was asked not to lay bricks for the week where it was below 5 degrees from the 4th to the 9th of December. And there is an extra 2 weeks because the contract administrator gave an instruction for extra work, and that was decorating part of the existing building. So overall, there's an extension of time of 3 weeks from the 23rd of November 24 to the 14th of December 24, and this explains how that's done. Now, the pro forma didn't include details of how it was calculated, but I recommend that's included to help both the contract administrator and avoid disputes with the contractor. So why do we extend time? And this is probably the most important part of extending time. The reason why we extend time is to allow the liquidated damage clause to work. Because if we didn't extend time and we had to vary the contract, then liquidated damages couldn't be recovered. So each time the client varies the contract, it would prevent the contractor from finishing within the agreed time. And without the extension of time provisions or mechanisms, then time would change from finish by a certain time to finishing within a reasonable time. And that's why we have the extension of time provisions within the contract. By having an extension of time clause, the contract administrator can adjust the time for completion so that the liquidated damages clause still operates and can be deducted from sums due. And as you know, it allows the employer to deduct liquidated damages from sums due or claim them from the contractor. So this is a very important Court of Appeal case that Lord Justice Colson decided, along with the Marshal of the Rolls and the President of Tribunals. And in this case, they considered the role of extensions of time. And in particular, they said it's so that time can be extended if there's an employer variation or some other relevant event. And they held that the extension of time provisions benefit both the contractor and the employer. And the contractor benefits because they know they'll not be held accountable for a delay they're not responsible for. And as I mentioned, the employer benefits because they know they will not be accused of preventing completion with a variation instruction, instructing more work, etc. So instead, the mechanisms will extend the completion date so that they can still deduct liquidated damages if the completion date, if they don't complete by that date. Now this slide has got a lot of points on it. I'm going to go very slowly, and I've got 3 contracts, and I'm going through all the bases on which time can be extended. So I'm going through standard contracts, the minor works, and the intermediate form of contract. So all the forms of contract allow time to be extended if there's a variation to the works by the employer. If there's any other instruction of the contract administrator requiring a variation, then time can be extended for that also. Also an instruction to correct errors, that's the intermediate form. Most of them are the intermediate form from now on. Or instructions by the contract administrator to clarify omissions, instructions to clarify inconsistencies between the contract documents, errors, omissions, and inconsistencies in the instructions, postponement of the work or any part of it, instructions by the contract administrator on a provisional sum, except for defined work, work in connection with a named nominated subcontractor, deferment of possession of the site or any part of the site, where approximate quantities were not reasonably accurate, suspension of the contractor when the employer has failed to pay upon a certificate, any impediment, prevention, default caused by any of the employer's team, work undertaken by a statutory undertaker as they require in their duty. So all of these we see IFC at the end. So they're all listed as relevant events in the intermediate form of contract. Exceptionally adverse weather, but of course I've added at the end only if they're working outside. Specific perils like fire, lightning, explosion, storm, flood, escape of water, earthquake, articles dropped from aircraft, civil commotion, threat of terrorism, authorities acting in response to those threats, strike, lockout affecting any trades, preparation of materials, etc. Any UK statutory authority, any powers that they have that may affect the work. Force majeure, which is a term that's very often used, which means greater force, which is a force that no party can be held responsible for. Now, as we can see, the vast majority of those are in the intermediate form of contract, whereas the standard and the JCT minor works leaves it more generic. So let's have a look at, if you're looking at extensions of time, does the contractor have any duty? So we've considered that they need to give notice when they can see that there's going to be a delay coming up. So I'm going to go through what the intermediate form of contract says, because it applies to all contracts, and I think it's 2.19. So the intermediate form of contract says, if and whenever it becomes apparent that the progress of the works is to be delayed, the contractor shall forthwith give notice of the cause of delay. Now, the important thing to notice is that it doesn't say if there's a relevant event or if it's happening. It says if it's apparent that the progress of the works or any section is likely to be delayed. So the contractor is under an obligation to notify a potential cause of delay or likely delay, and it says forthwith, which means immediately. So this obligation arises not when progress is being delayed, but when it becomes apparent it is likely to be delayed. Also, the duty to notify arises in relation to any delay. And we'll see later on the case concerning COVID. You think you wouldn't have to notify that, but there's a well-known case we'll see when notice wasn't provided and it was first considered by the adjudicator and then the courts, where the notice to delay wasn't given concerning COVID. Also, this duty to notify is not restricted to relevant events, as I mentioned. Neither is it limited to matters that have occurred. It's just likely delay. And any notice needs to be in writing, also stating the likely cause and duration of the delay. And the contractor has a duty to do all he can to mitigate that delay. I'm now going to talk about something that causes a lot of confusion, and that's two overlapping delays. And this is not two overlapping delays of the builder, but one of the builder and one of the employer. So the builder's in a period of delay, and the employer says, I'd like you to do this extra work. So what happens then? And this is often called concurrent delay. Now, this was considered by Lord Justice Colson in North Midland Building and Sidon Homes. And I must say, this is the exception to the rule. So in that particular case, they agreed, the employer and the contractor, that if there was an overlapping delay and the contractor was in delay, they wouldn't get more time and they wouldn't get more money. It would be ignored. But that was a contractual provision that was considered by the Court of Appeal, Lord Justice Colson, but that's not the common law position. I've got another way that this is being considered with overlapping delay in Peake and McKinney. It's quite an old case. In this case, there was defective pile foundations. And it took the Liverpool Council, who was the employer, over a year to make their minds up as to what they were going to do with these defective foundations. So the court decided, when it was looking at delay, just to make time at large, that the contractor had to finish within a reasonable time. So those are the two exceptions to the rule. And this is the rule, Water Lily and Giles Mackay. Where, in common law that is, where there is concurrent delay, one of the builder and one of the client, the builder gets extra time, but they don't get loss and expense. And we're going to go through the reasons for that. In City Inn and Shepherd, the Court of Appeal, this is another alternative, that the contract administrator could apportion the delay and they could give a fair and reasonable apportionment of the delay between the causes of delay. But again, Water and Mackay, Water Lily and Mackay is the general common law rule. And Keating confirms that, Keating 2023, if there is overlapping delay, the builder's in a period of delay and the employer asks them to do more work, then the contractor is entitled to more time based on Henry Boot and Malmaison, but not loss and expense, because the but-for test and causation is not satisfied. They would have been on site anyway, so they would have had to pay for their setup on site. And Keating 2023 also quotes De Beers and Athos. But the most important thing to remember from the first case, North Midland and Sidon House, is the contract can stipulate who's taking the risk for concurrent delay. So here we are, we're talking about a variation after completion date. And what I mean by that is the builder's late. They're carrying on working, they should have been finished, and we're going to vary the work. So this is concurrent delay. There's a delay from the builder, and there's going to be a delay from the employer. And the most important case is Balfour Beatty and Chestermount. And this was using a JCT standard form. Additional work was instructed under the contract when the contractor was in a period of culpable delay, already past the completion date. And the contract administrator added time to the existing extended contractual completion date that was in the past. And so when he added this time, the extension of time was also in the past. So they were instructing work on one day, adding time to the completion date that was, let's say, a few months ago, and then they were meant to finish the work a few months ago when they were being instructed, let's say, today. The date the builder had to complete was before the date the variation was issued. And Mr. Justice Coleman held that the contract administrator could grant an extension to the existing extended period, so the new completion date was before the variation was even issued. Now there is some slang terms, and very often people call this dotting. It's not a term I use, but that's where you dot on a bit more time onto the existing completion date. And it was very important in this particular case because the employer deducted £3.84 million liquidated damages in accordance with the contract. So we've been looking at a variation by the employer to the main contractor. What about a variation by the main contractor to a subcontractor when in a period of delay? So funnily enough, Carillion and MCOR 2017 was a very large dispute, and that was over the construction of the Rolls building, which is the largest courthouse in Europe. And they also had lots of disputes over that contract. And Carillion were the main contractor, and MCOR were I think they were the electrical subcontractor. And MCOR were late, and Carillion changed the work they had to do. And it was first referred to Mrs. Justice Jefford. And she followed the example in Chestermount we've just considered, whereby the contract administrator, or in this case, Carillion's contract administrator, could just add on to the existing completion date a reasonable period, to complete the variation. The contractor wasn't happy with this, and they referred it to the Court of Appeal. And Miss Recorder Jefford was held, the approach was held to be common sense, and the Court of Appeal upheld that, so that the periods that are granted as an extension continue contiguously. Now, I've brought the thesaurus today, and I do realize nobody uses books anymore. And I just thought, need for candor. I thought people may be thinking, what's candor? And I looked it up, and the explanation is so good, I thought I'd read it out. So candor means frankness, openness, honesty, candidness, truthfulness, sincerity, forthrightness, directness, plain spokenness, bluffness, bluntness, outspokenness, and then informally telling it like it is. So I think the contract administrator needs to use candor when they're dealing with extensions of time. And they need to exercise reasonable skill and care when considering extensions of time. Whether the extensions are of their own making, that is where they ask for work not to be done because it's cold, adverse weather, or following an application from the contractor because of some other reason that isn't their fault. And it's very important, as you know, to keep written records of what time is being allowed for each prevention event and why those periods have been established or how you've calculated them. There must also be a very logical, methodical assessment of how extra time has been calculated and why it's been awarded in each particular application. But of course, the contract administrator needs to study the specific contractual provisions, as we've discussed already with the case. And the administrator needs to keep a clear written record of what formed his decision in a permanent format that can be referred back to after the project is ended, just in case the extensions of time are challenged. Now, I discussed this case with Mark before slideshow, and Mark comes in, John Barker and London Portman Hotels. And the reason is because Tony Bingham was the junior counsel for one side, and the leader of the TCC was junior counsel on the other side. And this is an example where, in that case, it was an architect, got it all wrong, and got it so wrong, it went before the courts. And essentially, the court said there is no logical way that the architect has taken in assessing all the relevant events. There is no way that we can follow how he got the time from the relevant events. Now, normally, as we're going to look at, contracts have got an arbitration clause. So if there's a dispute concerning extensions of time or adjudication, the contractor can refer it to arbitration, and the arbitrator can open up the extensions of time certificates, review and revise them. Now, this was before adjudication. But in this case, it was even worse because the employer had crossed out arbitration. So there was no safety mechanism. I think I go into this in further detail. So contract administrators, they have a duty to act fairly. So in this particular case, Northern Regional Health Authority and Crouch, it was established that the contract administrator has a duty to act fairly when considering extensions of time. And as I was mentioning earlier, of course, the contract administrator, if it's an architect, they would be the client's agent. And the courts have established, particularly in the case of Portman Hotel, that it would normally be unthinkable for a client's agent to be independently administering a contract between a contractor and a client when they're working for the client. And that is why the safety mechanisms of arbitration, etc., are put into a contract. And we'll see in more recent cases where the court refers to adjudication in similar format. And the reason for that is because, generally speaking, the court only has the power to declare a decision on time valid or invalid. And that's why arbitration or adjudication is such a useful mechanism by which extensions of time can be challenged. But obviously, we're going to try and make sure that they're done fairly. And we're back to the London Portman Hotel again. And as I said earlier, the arbitration clause was crossed out. So the safeguard, this was before adjudication, was removed. And the court could consider the fairness of the contract administrator's extension of time and held that it was invalid. But it's very important that the contract administrator is seen to be reviewing all and any applications for extensions of time fairly and objectively. And I've put here that they should be inquisitorial. If the builder's claiming loss and expense, ask them from when till when, and where do you get the figures from, and why are you claiming that? And what loss and expenses for which delay? And it's very important that the contract administrator should listen very carefully to the contractor when they explain their applications at a design team meeting. And of course, the most important thing is that the contract administrator fairly and objectively formulates a written response explaining why they reach a particular decision on each application and each extension of time. So this is a nightmare. I've got it under contract administrators, Royal Brompton Hospital and Hammond. I think there are 10 court cases, and some of them went to the House of Lords. So this is case number 3, and there are 10. And this one went to the House of Lords, so Royal Brompton Hospital and Hammond. And the court considered the responsibility of the contract administrator. And when it got to the Lords on case number 3, they compared the contract administrator's responsibility to that of the contractor, and they said, well, look, they're clearly different. And they held that the contract administrator caused harm to the employer by awarding extensions of time when they were not due. The contractor was responsible for the delay and shouldn't have had the extensions. Now we see here I'm talking about case number 6. Come from case number 3 in the Lords to case number 6 before Mr. Justice Seymour. In that case, Mr. Justice Seymour held that all of the extensions of time couldn't be criticised, but there was one that was negligent, and he used the Bolam test to identify whether it was negligent or not. And of course, you know, the Bolam test is the test for any professional. Is there a responsible body of that profession would do exactly the same thing that this person who's extending time has done? And if not, then obviously it's negligent. In case number 8 of Royal Brompton Hospital and Hammond, the court held that the late and deficient information provided by the contract administrator also caused delay, which they were able to recover from the contract administrator. Now, we may be asking, why are they going after the contract administrator? And of course, as you know, that if you award an extension of time and it's not due and then the builder becomes bankrupt, the client has only got certain professionals that they can look to recover the money that was wrongly paid out. And of course, that's going to be the contract administrator. So I've got 11 cases. And the first one, we've got somebody present here who I understand actually worked on this case. 2024, Lord Richardson. I do apologize, this one, Energy Works Hull and MW High Tech Projects, 2022. So the first one, we're going to look at notices from the builder and whether or not they're critical, COVID. The second one, we're looking at disputes concerning extensions of time. The third one, second one is Mr. Justice Pepperell. The third one, 2022, Thomas Barnes and Blackburn, Darwin Borough Council is on a Judge Davies. The fourth one, Breakshaw and Red Key Concepts following an adjudication decision. The fifth one, Energo and Besta Generation, another energy generation plant case. This is Justice Cockrell. The sixth one, North Midland and Sidon Homes, that we've spoken about a little already with Lord Justice Colson at the Court of Appeal. And Carillion and Emcor, we've also discussed a little bit already concerning a variation to a subcontractor's work during delay. Rhinewood and Brown, a case with a scenario that could happen to anybody on any size project that I think we should go through in great detail. That went to the House of Lords. Balfour Beatty and Chestermount, which is the common law establishing for concurrent delay what happens in common law as opposed to contractual consideration. Temlock and Errol, I think if we get time, most people may have considered this at their part 3 or when doing a surveying course. And of course, the very, very famous Sutcliffe and Thackeray, 1974, which is also the House of Lords. I'm going to start off with this case, and I do apologize, the writing's too small. But I do know the case, and I can describe it for you. So essentially, it's during COVID, and the contractor didn't give notice of apparent delay, and the employer deducted liquidated damages, and the contractor said, well, it's kind of obvious we've got COVID, there's a delay. And so it went to the adjudicator, and the adjudicator decided, no, liquidated damages should be awarded. I think it's 285,000, just looking, I can't remember the amount. And of course, the builder wasn't happy at all, and so it was referred to Lord Richardson. So this is actually a Scottish case, but I think it'd be a similar decision in English courts. And I've got it here because obviously it's to do with giving notice of the delay, and it's 2024. So Lord Richardson, which was a standard JCT wording, 2016, the contracts have been negotiated and agreed by professionals, and the language was standard language. It's clear and straightforward. And it did indicate that the contractor's entitlement to loss and expense was subject to compliance with the conditions precedent with regards to the timing and giving of notice. And that is to give notice when it becomes apparent there's going to be a delay. Now, this particular dispute was concerning COVID. And Lord Richardson said the clauses set out a clear and practical series of steps that must be followed with regards to giving notice of apparent delay, and they weren't followed. Now, it's worth looking at the contractor's arguments, which do seem, on the face of it, reasonable. So the contractor said that as a result of a decision by an adjudicator, it created such a disproportionate result, lacking all business common sense, in as much as they couldn't claim loss and expense because of having the site set up over COVID. But of course, the contractor was held that they must comply with the requirements to provide notice as the contract required, whenever a delay becomes reasonably apparent, if they're to take advantage of the loss and expense reimbursement provisions. So I think this case, which is the most recent one I've got, 2024, that essentially it's saying that if the contractor doesn't provide the notice of delay when it becomes apparent, and I'm afraid to say a lot of contractors leave it till the end of the project and they bunch them all up and they kind of send them all, oh, this is all the delays I want to claim. But if they haven't served the notice when it's reasonably apparent based upon the standard JCT, then unfortunately they're unlikely to have followed the contract, and that the extension of time should probably not be awarded. Now, we have somebody present who I believe worked on this, Energy Works Hull and MW High Tech Projects Limited. And I just want to give you the figures to show how drastic things can get concerning extensions of time. The construction cost for the project was £153 million. This was an energy generation, refuse to energy generating plant. Okay, so the construction cost was 153 million, and they were almost finished. They were 11 months after they should have finished, and they stopped. And they went to court, and the claim was 131 million pounds.
Okay.
And there were 10 barristers. And this is just over extensions of time, and it just shows how important extensions of time are. The project's 153 million, and there's a claim of 131 based on the dispute over extensions of time. So essentially, the dispute was over extending time. And whether time should have been granted or whether the employer was entitled to terminate the employment of the contractor. And also the judgment itself in the TCC ran to 195 pages. And this is just over a dispute on extending time. Now, I'm going to summarize what the case is about. So essentially, there was a claim that the employer was in breach of contract, and therefore various extensions of time were made. And of course, when the employer did not grant, or the contract administrator didn't grant them, the contractor stopped work. Now, the court had a look at each of these claims of a breach of the contract and found that none of them were correct except for one. And that is the refuse that was going to be incinerated and used to generate energy didn't have a high enough calorific value. And that was the only breach that the employer made. And that was held not to affect the progress of the works. So what the court was asked to do was to consider whether any, on the balance of probabilities, whether any of the breaches that were complained of affected the progress of work. And none of them did. And all of the delays weren't caused by any of the alleged breaches of contract. And there was only one breach concerning calorific value. So in this particular case, the claim for extensions of time failed. And it was held that the employer was entitled to terminate the contract under common law and for repudiation of the agreement because the contractor stopped work when the work was not complete. So although the employer claimed 131 million pounds, they got 11 million pounds damages and 2 million pounds for defective work. And the reason I've put this case in is because if a contractor is claiming more time because they're saying the employer has breached the contract, it just shows you've got to look at each potential breach. And then if there is a breach, does it affect the regular progress of the work on site? And if it doesn't, then of course they shouldn't really get an extension of time. Now this case brings home, some of you may know it, Thomas Barnes and Son, and Blackburn and Darwin Council concerning the bus station in Blackburn. And it's a very sad case. And you'll see there in the facts, the last line of the facts, it says the builder blamed the contract administrator for all the problems on the project, which is normally the case. But essentially, this was a case where there were minor defects and there was delay, and the builder thought they were doing a good job, and the local authority didn't, and they terminated the builder's employment. The builder went into liquidation, and the administrator took over. And the Thomas Barnes and Sons, the family business builders, they said, well, we still think we're owed money because they didn't extend time. And so, and this is how serious it got. They actually put up personal belongings in order to pay for this court action. So obviously they, probably their homes, etc., they were quite willing to stake this in their claim against the local authority. So it's really got a personal touch to it. And this was on the JCT standard form. Case was decided by His Honour Judge Davies, and he considered concurrent causes of delay, which we've spoken about. And he also considered Water Lily and McKay 2012, which is a well-known case. along with De Beers and Adyard Abu Dhabi, 2011. And what His Honour Judge Davis decided, as we've established, the general common law rule is if there is concurrent delay, the contractor is entitled to time if the employer causes delay, even if the contractor is delayed anyway by their own actions, but they're not entitled to loss and expense. And that's because of the but-for test. But for the employer's instruction, the contractor would be set up on site anyway. So they haven't got a claim for loss and expense. They just get extra time. Now, concerning His Honour Judge Davies' consideration of the Water Lily and McKay case, he came to 4 conclusions. The court can decide what the delay was, even if the experts on both sides don't agree with it. I thought it was quite interesting. If there are 2 causes of delay, His Honour Judge Davis said it's normally the one with the longer period that should be considered. And it's not necessarily the last item of work which is causing delay. And in this particular case, there was a lot of disputes concerning deflection, whether it was in tolerance or out of tolerance, and structural steel. And so point 4 is raised, where one side perceives the problem to be more than it actually is, it does not actually result in an instruction or a variation, just ignore that completely. So unfortunately for Thomas Barnes and Son, it was held that the termination of their contract was lawful. 27 days were added to the program, which had absolutely no effect on the money. So unfortunately, they lost that project, that court case concerning that project. So in summary of that case, a relevant event entitles the contractor to more time if concurrent with the delay caused by the contractor, but it does not entitle to loss and expense. Breakshaw and Red Key concepts. This is a very, very interesting case. And I think it's the sort of case that an architect would experience. And this is following an adjudication. Breakshaw with the client, Red Key concepts with the builder. And there was a dispute as to whether liquidated damages could be recovered when the contractor stopped work. The client claimed the liquidated damages after the adjudication of £285,000, and Red Key made a Part 8 declaration saying they're not entitled to it. And what they said was, we can't build this building because we've been asked to build it, but it's 1.5 meters taller than the planning permission allows. And so the court had to consider whether this was a valid reason for the builder to completely stop on site. And His Honour Judge Johns QC held that the liquidated damages, as the adjudicator decided, were due because the simple fact the contract administrator had not provided an extension of time, allowing Red Key to stop work. And the reason for that is because the risk concerning the height of the office was an employer risk, wasn't a risk for the builder. The builder was still to build it, and if it was the employer's risk, if there was a problem, then the employer would have to pay for any extra work after it was built. So in summary of this particular case, I think the contract administrator needs to explain very, very clearly the reasons why an application for an extension of time has been refused, to avoid the costs of the parties going to court. Now, this is another energy generation case. And this case is all about, and I do apologize, I can read it, but it's probably a bit too small for you. And it's all about timely responses to applications for more time. And this is what's concerning the FIDIC Grey Book, Silver Book. Now, in this particular case, the subcontractor was making lots and lots of applications for more time, in particular because they found asbestos. It wasn't in the contract. It was surprised to find it. And the subcontractor was making a claim for more time and more time, etc. And they didn't think the main contractor was responding quickly enough. And so they stopped work. And it obviously went to court. So the main contractor affirmed the contract, said, "You're still my subcontractor, please come back." And then the client sacked the main contractor, and of course, the main contractor sacked the subcontractor. And believe it or not, the subcontractor was suing the main contractor when they were the cause of the whole project coming to an end. So the dispute between the subcontractor and the main contractor, where the subcontractor was looking for money they thought was due from their lawful stopping of work, and Mrs. Justice Cockerell, concerning the FIDIC agreement, held that the main contractor had been entitled to consider the subcontractors leaving their abandonment, and they had been right to seek damages as a result of this. And the reason for this is that if a subcontractor's applications for extensions of time have been valid, but they were not granted, well then of course, as Mrs. Justice Cockerell said, they've always got the option of referring it to adjudication or arbitration. It's not a breach of contract that brings the contract to an end, that the contractor can stop working. So the subcontractor had been wrong to consider the failure to grant extensions in a timely manner as a breach of contract. And as I mentioned earlier, this was all to do with the discovery of asbestos, which wasn't appreciated when the contract was entered. But according to the notes on the case, that particular risk was identified and allocated under FIDIC Silver Book as the subcontractor's responsibility anyway. So they stopped work based on a risk that was their responsibility. Now, the summary that I learned from this particular case is that we need to consider extensions of time very promptly, because people get contractors, subcontractors get very worried if they're not responded to reasonably quickly, and also to respond to them in unambiguous language. Now, we have briefly discussed this earlier, and I'm going to deal with it very, very quickly. And this is a case where very, very clever solicitors for the client and for the builder changed the contract, changed the common law rule that concurrent delays mean more time, but not more money. They changed the rules so that any concurrent delay, the contractor doesn't get more time. And that's what both sides, on the basis of relying on professional advisors, entered the contract. And so the builder said, well, this can't be fair. The client's delayed the work, and I'm being hit with liquidated damages for a time when the client's delaying it. But of course, it was concurrent delay. And the court held that actually, if you agree it and you overrule the common law rules, then that will apply. Now, the case first went to Mr. Justice Fraser, and then the builder appealed it, and Lord Justice Colson said, you can contract out of the common law principles using clear express terms. Now, we have considered this very briefly, so I'm very, very briefly going to mention it. It's very much similar to Balfour Beatty and Chestermount. If there is concurrent delay, and in this case, it's the main contractor and the subcontractor with the Rolls building, the courthouse on Fetter Lane, that if there's a delay caused by the main contractor to the subcontractor when the subcontractor is in a period of delay, the common law position is that they get more time but not more money. This decision was reached by Miss Recorder Jefford, and then the contractor appealed, the subcontractor appealed, and it was affirmed by Lord Justice Jackson, Simon and Phlox, and that's quite recent, 2017. And Miss Recorder Jefford followed Balfour Beatty and Chestermount. Now, this case, Mark and I have discussed at great length, and this is the case that anybody could have on any project, and it's extremely complicated. and I'm going to try and explain it. The contractor applied for more time, and before the contract administrator issued a non-completion certificate, before considering this, the contract administrator issued a non-completion certificate. And then immediately after, they issued a certificate for payment. The employer took the non-completion certificate and the certificate for payment and paid the amount on the certificate, deducting liquidated damages at the rate in the contract based on the non-completion certificate. And then before the final date for payment, the contract administrator reviewed the application for more time and granted it. So we have this very, very peculiar situation where the employer has deducted liquidated damages based on a non-completion certificate that was cancelled before the final date for payment. Now, obviously, the builder wasn't at all happy with this. And as you can see, it's gone to the House of Lords. And the House of Lords, I'm just going to read what the Lords said, that the employer, in accordance with the notice to deduct under the terms of the JCT followed the valuation, was entitled to deduct from the payment notice a sum representing damages for non-completion, even if the certificate of non-completion was superseded with another certificate issued afterwards. So that's, these situations arise, which are very, very complicated. But of course, the House of Lords considered if the client had waited till the 5 days to pay and the time wasn't superseded with an extension of time, then he would have lost his ability to deduct damages. So it's kind of catch-22. Now, this is the most famous case. This is the common law case where concurrent delays are established, and it's Balfour Beatty and Chestermount Properties, where Mr. Justice Coleman said, if there is a period of delay and a variation instruction is given, you tag on the period of time you will associate with that delay to the existing completion date, even if you end up with a date in the past. And the reason for that is the object of fixing a new completion date was to make allowance for the variation. Obviously, the court considered that if you did it differently, as the builders say, you add time from the variation time, there could be a variation of 1 day, 1 day's work, let's say decorating a store, when there'd been 2 years of delay. And if you had to add time on from when the variation was given, then of course the client would lose 2 years of liquidated damages as a result of a variation of 1 day. So they said that couldn't have been the intention. So I think, Mark, you say it's called dotting, is that correct?
Dot on.
Dot on. There
Yeah,
you
when
are.
you dot on the delay caused by the original variation.
So we'd be pleased to know there's only 2 more cases. Now, a lot of you may know these 2 cases because they're quite old. Temlock and Errol. Now, this is where the contract administrator was trying to be smart, and it didn't work out. And they thought that by putting nil, where it says the amount of liquidated damages, and leaving for the period nothing, so it said nil amount with no date, they thought this would encourage the builder to work faster, but of course it didn't. So they got to the project was over and the employer wanted to get some money, and they went to the court and said, our putting nil meant that we could claim unliquidated damages. Yes, we can't claim liquidated damages. They said we can claim unliquidated damages. That is, the builder didn't finish in a reasonable time. But of course, the court had a look at that, and the court said, well, actually, you're putting nil shows that you don't want to recover any damages for any lateness, and you can't claim liquidated or unliquidated damages. Now, I've put a note in very, very small text there of what Mr. Duncan Wallace QC says in Hudson, the 11th edition. He doesn't think it's good law, but it still is good law, 1987. But essentially, the summary, what I'm saying is that if you're going to amend a standard form contract, when you've done the work, look at it and view it from the other side's point of view and be as critical as you can be. Is it ambiguous? And if it is, please get rid of that. Now, I'm on my last case, Mark, and this is Sutcliffe and Thackeray.
Okay.
Probably the most famous case concerning contract administration. And this is where the House of Lords overruled a lot of, I'll call them bogus cases that went before, that said contract administrators are arbitrators, they can't be held accountable for their work. And so the House of Lords looked at this particular case, where in this case, the architect had valued the work, provided the value to the quantity surveyor, and didn't tell the quantity surveyor all the defective work, which should be deducted. And the builder went bankrupt. And of course, the employer said, look, I've got all this defective work. You shouldn't have certified the full value. And the question was, is the contract administrator an arbitrator, or are they just a professional? And to cut a long story short, they're just a professional who needs to be very careful and to try and get their task right, and to not inform the quantity surveyor of the defective work, have a more accurate valuation to be paid. The architect was negligent. I'd be pleased to know that was my last slide. And in summary, essentially what we're saying is to deal with claims for extension of time quickly. If there's concurrent delay, they get more time and not more money, unless the contract says otherwise. And there's a lot of other cases in the slideshow you can look at for other examples. Thank you very much.
Thank you, Seth. Chap right at the beginning was going to raise a question. So, and what we'll do is we'll repeat them, because I was aware that 2 weeks ago we didn't pick them up on the radio mic. So take one at a time, if we may.
Okay, I'll start off by admitting I'm a contractor by background. So yeah, I'm from the other side. A couple of minor things. You said that the contractor was requesting delay. It does, or an extension. He's no obligation to request an extension. He's an obligation to notify a delay. Mm. And there's a significant difference, because then you need to look at the format. A question, giving a notice within a monthly report, would that satisfy, because he could be notified of the delay? He certainly isn't requesting an extension, but he is complying because he's notified. That's a question, but it is a significant difference.
So you, hang on, let's just take them one at a time. So is the question, is notification via a means such as a monthly site meeting going to be sufficient to satisfy the requirement under the contract for the contractor to notify or to mention that they are that a delay is likely?
To notify a delay.
Yes.
There's no requirement for them to request an extension. We all do because it's strategic, but that's all their requirement is: notify a delay.
Okay.
Yeah, go on.
That isn't enough.
Okay.
Well,
Because the contract requires the person who's notifying to notify the cause of the delay, to notify what can be done and how to address it and how long it's going to be. So the contract does require more things. Now, with regards to whether putting it in the notes of a meeting is sufficient, that's a very good question. Now, these are all questions that are kind of, I'm kind of looking at the law, and I state the law, and you're looking at very, very precise grey areas.
they are grey areas.
But I think they're very, very, very good questions.
Also, I think you said that.
But I would be inclined to agree with you. As long as they say, we think it's going to last so long and we think the implications are, and they go into that, and if it's in the design team meetings, whether it's monthly or weekly or whatever.
Could we just come back and just to deal with that one on its own? But then, of course, it's always going to be dependent upon the form of the contract.
Yes.
So we picked out, or
Yes.
Seth chose to pick out the minor works. If you were to then move up the
Yes.
hierarchy, you will find that under the more complicated, or more
Yes.
involved forms of contract, then there's a requirement for the contractor to notify of what the delay is, under which event, and indeed has then got to request an extension of time, specifying the term under which he's seeking it. Of the
identifying the cause.
Yes, but if he's going to class it as a relevant event, he has to identify the relevant event. Yeah.
But what I was saying, and I think you're highlighting that, is it doesn't matter if it's a relevant event or not. Any delay because it was COVID. And of course, COVID had never been, around before, and that was the case that went to adjudication. So any delay at all. So these are all very good points, and they're kind of cutting edge. And I've just gone over the one case that was the adjudication one.
You said the contractor has a duty to mitigate. I disagree. He has a duty to prevent using best endeavours or using endeavours, I can't remember the wording, to prevent delay. If it's occurred, he has no obligation to mitigate.
Hang on.
It's not a requirement. And I think that's quite, again, a significant difference. If you suffered a delay because you didn't see it coming, something happened, it's happened. The contractor is not required to mitigate or spend money. He's got an obligation, I think, an implied obligation to mitigate costs. But there's no requirement under the contract that I've ever seen.
I think I got that from the JCT guidance. So my slides, yeah, I've got the guidance here with me. If I can show it to you after. Yeah.
Spending money. And when you come on to the extension of time for inclement weather, as a contractor, if you instructed me to stop building outside because it's cold, I claim extension time with money.
Well,
my risk, and I could protect the works.
But what I was saying is, rather than wait for the cold weather, you can see it next week. Be preemptive and say, this is the forecast. You may be a very big contractor, is that right? Okay, so a lot of us here may be working with smaller contractors, less educated than you. And what I'm saying is, if you've got to work on a house, you've got a builder who's got maybe 3 small projects, looking at the weather forecast and it's cold, you can say to the builder, look, it's going to be less than 5 degrees. Don't do the brickwork next week, and then be proactive and give them the time anyway. There's no point waiting for more time, which I think we discussed, didn't we, Mark, when I was doing the slides
Previously.
But I think the mitigators the gentleman mentioned is in the, because I was using the guide to the intermediate form in the slides. I think mitigators mentioned here.
It is, but it doesn't say you need to spend the money. That becomes like your acceleration. It's what's reasonably practical.
Yeah, in terms of reprogramming the work. I agree with that.
Possibly at least something that is,
but not so money. Yeah. 2 final ones. One is, you mentioned defined provisional sums. I struggled since the end of SMM7 to find the definition. I don't think there is one in the JCT form of defined and undefined. I don't think there is. We use it as a shorthand because old people will remember defined and undefined. But I don't think it's relevant at all in JCT. And I think you could argue that all provisional sums therefore be classified as old undefined. There's no other definition.
Unless you've specified it in the contract. That's right.
Yes.
Yeah. And well, don't get me started on PC sums, because you still see those being quoted by people.
Do you want to mention that one in your microphone, because people may not have?
Oh yes, there was. Sorry, just in case the query was a distinction between defined and undefined provisional sums, which of course was something that used to be under SMM, and people still rely upon it, even though SMM is now being substituted with the new rules of measurement, and people may be still referring back to something which is outdated, but has just become a term of art, often misunderstood. And as I say, and I then mentioned PC sums, which is the same thing that hasn't been in the JCT since 2005, and people will still quote it all the time. Any other questions from? Final question. Okay. Yeah.
And it's about the current delays.
Yes.
And I think they're exceptionally rare because you're not referring to potency. You can have one delay that's causing a delay, critical delay, and another event that's not causing a critical delay.
Yes.
Well, that's not causing a delay. It's just an event.
Well, I'm picking this one up.
Yeah, please do. Do you want to mention the question just in case people?
Yes, indeed. So the query was to do with concurrent delay. So concurrent delay, as Seth quite rightly said, is a situation where you've got an employer risk item, maybe a variation or something that the employer has instructed, which is then going to impact time, and you've got the contractor in culpable delay at the same time. And it is arguable that the two things are overlapping and interlinked. And so we have the cases, although they differ between the Scottish law and the English law, but the English method arising out of Aikenhead in Walter Lilly is that there will be an entitlement to time, in other words, a defence to liquidated damages, but there wouldn't be an entitlement for the contractor to have extended prelims, for example, and money. What the cases also say is that actually, in practical terms, it is very, very rare that there will actually be concurrent delay, because normally there will be one of the two causes that will actually have been the thing that was causing the end date to go out. And so it does get terribly complicated in trying to find situations where you really do have two contractor and employer delays which are identical and so interlinked that they will be truly concurrent. Well, you know, the judges have done very well in their definitions, but actually practitioners argue all the time that that doesn't really happen on site. And there's normally some good way. And of course, if you're working as a delay analyst for a contractor, you'll prove that it was the employer one that was the cause. And I'm sure vice versa. Now, that doesn't answer the question. It just says we're getting into now the sort of dark arts of extensions of time and delay analysis. And if you put 5 delay analysts in a room with the same facts, they come up with 5 different answers, depending on who's paying them. But that maybe I'm being a little bit cynical. Right. And does that make sense?
Absolutely.
Yeah. Paul.
It's interesting. Yes, it's always extension of the time. I can imagine I've run a few fairly minor jobs. It's normally the way it works out. But say you had very clement weather, no problems with brickwork, etc., and someone's got to make an estimate of what time it is. It's only a human factor. Is there anything for a reduction of time, and how has that ever come up? Is there ever been taken? It just occurred to me, if you finish earlier, or is that enshrined in JCT?
Well, apparently.
So the question is, if nothing goes wrong and it's all going swimmingly,
Yes.
Are there any grounds for somebody reducing the time? I haven't answered that, but Seth, what
are the ramifications?
Well, there is case law on this, actually.
Can I just clarify? Are you saying if they finish early, they get money? Extra money? Is that what you're saying? Is that what you're saying?
No,
so there's liquidated damages if
you
they're
said
late.
could time be taken away?
Well, it says extension of time. It sounds like it's making it longer.
Yeah.
Is there, I'm just thinking out of the box. Is there any question? Sometimes jobs finish a little bit earlier than you expect.
I mean, I had this discussion with Chris Myers, who gave talks here. And if there's liquidated damages, does it mean there has to be a bonus if they finish early? I don't think there has to be.
That's one thing.
But can I just say the Temlock and Errol case where they put nil, that was all based around bonuses for finishing early.
Yes,
and the client didn't want to have a bonus for finishing early, but they wanted to keep them keen, so they put nil in because they had this argument bonus and no bonus, LDs and bonus, and so they just put nil in. And so that's where so the nil wasn't people being stupid. It was to do with considering whether or not you have to have a bonus if you've got liquidated damages. Now, I don't think you do, and it's the freedom of contract.
Well, let's just answer this question first. Just on the matter of time, there is a case, and it's something like Red Lion, but I can't for the life of me remember what it was. But the contractor, let's just say it was a year's contract. The contractor was well ahead. The contractor, therefore, wanted information earlier than the contracted period. And he tried to claim that he had the right, because he was doing swimmingly well and getting ahead, that he could demand all that information. And then he tried to claim damages, or he tried to claim extras for not being able to achieve the early completion that he wanted to.
Yeah, I remember.
And the case law in this said, well, that's all very interesting, but actually you contracted for a year. The contract administrator only had to meet the timetable to go along with the year. Yes. So, and secondly, of course, the JCT, and although the contracts can be doctored, and I have seen weasel words being written in, the standard forms are that if an extension of time is being given, you can't then take it away. So it's a one-way valve. You cannot shorten the time. So you can take it into consideration with later events. So you could then revisit events, and you could decide that maybe we were overly generous, etc., etc. But what you cannot do is work backwards and give them less time. So if therefore you had other things happening later, you might have the ability to sort of all wrap it up together and say, well, on a sort of but for, we might have given you some more, but we gave you this other time over there, which in reflection was a bit generous. You're then going to review it and pull them all together for the purposes of a supplemental and a subsequent extension of time case. But you can't take the time back. You can't do a lesser extension of time.
So even if surely if it's a VO, you say, no, I don't want to do.
Yeah, but you can't, if you take work out, you cannot shorten the contract period.
I didn't know that. Yeah, so even
No, you can't. If it's a 11:10.
You're not allowed to do that.
I
No.
discussed that last time I
Yeah.
was here on practical completion.
Can reduce the extension
They can
by
reduce.
omitting work.
Yeah.
Unless the contract's changed. Because if the contract completion date is the 30th of June, it can never be less than that.
That's right.
But if you granted a 6-week extension, then subsequently you omit the external work or the playing field or where it has to be, you can reduce that, I believe.
Only if it was going to affect a later extension of time. You cannot take the time back from the one you granted.
Or deed of variation, but that's why people go for a deed of variation.
Oh, no, it would have. Yes, but a deed of variation has altered the contract.
Yes. So
Yes,
that means
it's not a variation to the contract. It's a variation of the contract. So obviously,
whereas an EOT can be taken back only
Yeah.
on the grounds of omitting work. That's the only ground.
there could be a variety of reasons, but that would be.
Couple on
Oh
the
yes,
right
good.
to-
Good.
One is, you talked about a duty to act fairly or assess EOTs fairly. Who is that duty owed to, and can a contractor sue for breach of that duty?
Good. Okay. Now, Mark and I have discussed this as well. So generally speaking, of course, the contractor does not sue the architect or the contract administrator. They sue the client, and then the client sues the contract administrator or the architect because they got it wrong and they're being sued. So unless, of course, there's a novation, which I've considered a number of disputes where the contract is novated from the employer to the contractor, and then the architect then works for the contractor, and then all the rights that the employer had are transferred to the contractor, and then the contractor can sue the architect. But that's normally in design and build. I think that's the only case where the contractor can go directly to the architect and sue the architect. But the duty is owed both to the contractor and to the client. But the contractor can generally, on most contracts, only sue the employer.
Follow it through. If we come out of the case law, the architect or the contract administrator has a duty to act fairly. All right, so it's a duty owed to both parties to act fairly. But if I understand the question correctly, the cause of action, exactly as Seth says, would be the contractor would have to pursue the employer.
I think the question is,
Yeah.
in what sense is a duty owed if that duty is not enforceable? There is no duty.
But it is enforceable. They sue the employer.
It's because
They're entitled.
There's a
Yes.
tripartite contract between the contractor, the employer, and the contract administrator. And part of that is the contract administrator will act fairly. And if the contractor doesn't think they're acting fairly, they will then sue the employer, because the contract administrator is.
But they wouldn't be suing them for breach of the duty to act fairly. They'd be suing them under the contract for their entitlement to essential time under that.
Well, that's right, but that's how it manifests itself. So we have the Portman Hotels case that you know very well, where in that case, the architect, there was no relation between the relevant event and the times, and the judge just held that the extensions were invalid and there was no arbitration clause. And they didn't want to refer it back to the contract administrator because they knew he just wouldn't get it right. They just lost total confidence in them. And so that shows that there is a duty owed to the builder, and that the builder can refer it to adjudication or arbitration if they're not happy. with the period. But essentially, it's a difficult case because as all the cases are saying, that the contract administrator, if they're an architect, they're the agent of the employer, and they probably not the best person to be administering the contract. But because there is arbitration and adjudication, it's allowed to happen because there are these safety mechanisms, etc. Because obviously they're being paid by one side, so there's a natural tendency to, one would have thought, to favour that side.
And the second one is where you're dotting on an extension of time. Where for what period do you value the loss and expense?
I do apologise if it's concurrent. There's no loss and expense.
Sorry, no, not concurrent. I'm talking about the questions about variations
Okay.
after the completion date.
Just in case it's not picked up. So if there is an extension of time, a valid extension of time, and the contract administrator has done what he or she has got to do, which is dot on the time, then for what period a liquidated, for what period would loss and expense be claimable? Is that what you're getting at?
You get an extension of time.
Yeah.
The completion date is May. You
Yeah.
have a variation in June, but your extension of time is back in May because it's
Yes.
dotted on to the end of that completion date.
Yes.
For what period is the loss and expense associated with that event value?
Well, James, you might have a view on that as well, but I think that I'd be saying it would be valuing it at that for that period. So, so whilst let's just say that an event happened in June, the job is supposed to finish in November. A month gets added, so we end up with the extension of time being dotted on from November to December. But the event that caused it happened in June. I'd be looking to pay the loss. I'd be looking to claim for the loss and expense at the period when the delay was caused. In other words, it's going to be the thickening of prelims at that stage. You often get this. People are sort of saying, oh, you didn't, by the time that you got the extension of time, there were no site huts on site. You got rid of the finishing foreman, et cetera, et cetera. But if it's happened when you've got all of your resources on site, that is the period for which you'd be claiming loss or expense. And that I think is the right period for it to be valued at. Not the end of the job, but when you're actually in the middle of the fight at the time that the delay occurred. Other questions? There was, sorry, did you have a question? You were waving earlier on.
Oh,
No, no.
well, I was sort of going back to that, reduction of time.
Okay.
I mean, if let's say reducing the scopes or mission works, and the scope actually is on a critical path. So let's say I'm the client, I want to give a finishing works to someone else. Can I then reduce the time?
Well, firstly, so the question is, if you wanted to take work out on something that was on the critical path and give it to somebody else, could time be taken back? Well, there's two issues there that we would take considerable objection to. Firstly, you can't take work out of a job and give it to somebody else. That's a repudiation of the contract and likely to give them grounds to, claim grounds for termination, and then the contractor would be entitled to the loss of profit on that. And secondly, you can't take the time back. You can take it into consideration in terms of extensions of times that you're awarding, but you cannot take time back, not if you contracted, not without a deed of variation, moving the goalposts entirely. Does that make sense?
It's interesting, yeah. I think a lot of clients sometimes.
Oh, people think they can do it, but it's all down to the words of the contract. So unless they've changed the contract wording in the first instance, all the standard forms would say you're in a contract for X amount of time.
Would that even variation is the option?
Sorry?
Deed of variation would be the option?
Well, a deed of variation is basically rewriting a new contract. Totally.
So if the contractor doesn't dispute that, you could formally.
Oh, by agreement, I'm working on a case at the moment where the job, they doubled the length of time by agreement between the two parties, issued under a deed of variation. So under a deed of variation, you can do whatever the parties wish to do by agreement. Yes. Paul.
Well, it's more generic, but I think it's relevant to any professional, not all professional. The Bolam test, it's vaguely heard of it. It sounds much more and covers that. A lot of professional work.
Well,
I imagine a lot of people here are members of more than one organisation, a lot of RICS, but I'm sure
RIBA, whatever.
Yeah, that's true. professional body should you adhere to if there's
Oh,
a conflict? And
well-
no, has it ever come up? You know,
Well, the question is that the Bolam test has been mentioned, and then of course, if you've got multiple professional hats that you wear, but Seth, do you want to? I've got an answer, but if you want to take
The
that,
Bolam test, let me just go through the Bolam test. 1957,
Yeah.
psychiatrist gives the patient electric shock treatment. They suffered broken bones as a result of the convulsions. And the question was it normal to give the patient anesthetic? Was it normal to strap them loosely, or was it normal to leave them? And I think it was Mr. Justice McNair said, well, the test is there a responsible body of that profession would do what that doctor did at that time? And that is the test. So if you're administering a contract as an architect, it would be, is there a responsible body of architects would do what that architect did at that time? And if you're administering a contract as a surveyor, is there a responsible body of surveyors would do what you did at that time, etc.? Or if you're an engineer, is there a responsible body of engineers? You know, case of Eckersley and Binney, where the water pumping station blew up and
methane
killed
explosion.
10 people when they went to open it, town council. They looked through all of what the engineers were reviewing at the time, and was it reasonable for an engineer to have reviewed? When the water came up, it brought the gas up, and the man from the local authority lit a cigarette and blew them all up.
Yeah.
And so in that case, which went to the House of Lords, you've got to look, is there a responsible body of engineers would have done in that particular case what?
As you know, yes, architects and building surveyors can both run jobs. It'd be interesting if you had a small domestic job, which one I would obviously adhere to RICS.
Well, that's right. If you're a surveyor, they'd look at the surveyor.
Yeah.
So you could only have an expert surveyor deal with a surveyor
Yeah,
or
I
an
know
expert
that one.
architect.
Yeah, that's not the Bolam test, isn't it? It's someone who's a retaining wall, but they got an engineer and a surveyor.
Now, the Bolam test is the psychiatrist.
Yeah, but we're talking negligence.
Okay.
Yeah.
What should concern us all.
No, but what we're coming back to though, and following on from this body of knowledge, that what was the state of the art in a particular field
Yes,
at that time?
At that time.
And then what you're going to do is effectively, you've got to say, what would a reasonably competent, and then you've got to see what the person's acting as. So it may be that it could be a QS who is acting as a contract administrator. It could be an architect who's acting as a contract administrator. It could be a building surveyor who's acting as a contract administrator. But I would suggest then that you're going to look at what would be expected of a reasonably competent contract administrator, because that's the role that they're performing.
That's my point.
And in which case, but you then one, I'm guessing that people would then start to look at, well, we came to you as an RIBA member. You've been appointed under an SFA 99, which so many people still seem to operate under. You know, that would then be a contract between the employer and the architect as to what grounds they're going to be dealing with. So then I'm sure that it would be by the standards expected of a reasonably competent architect acting as CA.
Which wouldn't apply to you, wouldn't apply to me.
Well, no, but it would still be if as an RICS member, then it's going to be the RICS standards expected of a reasonably competent. Yeah. I'm conscious, ladies and gentlemen, that we're coming up to 8 o'clock, and I don't want to extend this on
Online questions.
a lovely evening. Is there anything more? Oh, we're good. Okay. So, ladies and gentlemen, I'd like to, in a second, thank Seth, but just to say that obviously, again, lots of questions. It sounds as if I've managed to muck up and send the wrong link to a lot of people online. So I'll be sort of sending this out to people, and you will get the video if you've attended tonight. 2 weeks tonight, I'm going to be looking at the thing that people get sued over most at the end of the day, and that's to do with money. It all comes back to money. So trying to whet the appetite, and I make no bones about this. I want, you know, as many people to be here in the room so we can have a good debate as well. But we'll be talking about the sharp end of money in 2 weeks' time. And but I'd just like to ask the people in the room, please, to show your appreciation of Seth's work this evening. Thank you.